Good afternoon, ladies and gentlemen. My name is Adrien Meyer, and you're watching The Future of Europe. Today, we discuss a significant development in the realm of intra-EU arbitration. Joining us is Charles van den Broek, a legal graduate specializing in international arbitration and EU law. Charles, welcome.
Thank you for having me.
Now, let's dive straight into the recent judgment by the Court of Justice of the European Union in the case of Comstroy v. Moldova. Could you provide our audience with a brief summary of the case?
Of course. The Comstroy case resolves around its dispute stemming from an electricity supply contract under the Energy Charter Treaty. What is quite interesting about this case is that it is extra-EU, The conflict itself is between Moldova and Ukraine, both of which are not in the EU. Originating from a 2016 preliminary question by the Paris Court of Appeal, the case involves Ukrainian company Comstroy, which acquired Anagolia, a party to the original contract. The dispute arose due to payment default, prompting legal action and an ad hoc arbitration proceedings against the Republic of Moldova under the ECT Article 26, paragraph 2c. The tribunal that was found in Paris initially found Moldova in violation, ordering significant compensation. However, after appeal, the French Court of Cassation sought clarification from the Court of Justice of the European Union on the definition of an investment under the ECT.
Okay. And could you please point out the key points of this judgment for our viewers?
Certainly. In the judgment, the Court of Justice of the European Union ruled on the compatibility of intra-EU investment arbitration proceedings under the Multilateral Energy Charter Treaty with EU law. The court affirmed its jurisdiction to interpret the ECT and applied the ACMEA reasoning to find such arbitration proceedings incompatible with EU law. Additionally, as it was initially asked to the court, the CJEU clarified the interpretation of the term investment under the ECT. For those who don't know, the case ACMEA is a judgment of the European Court of Justice in which it was found that the arbitration clause in an international investment agreement between two European member states was incompatible with EU law. The Comstroy ruling marks a significant evolution from the landmark ACMEA decision with far-reaching implication for investment arbitration within both existing and forthcoming investment treaties and agreements concluded by EU member states or the Union itself.
And could you elaborate on how the CJEU came to its decision?
Absolutely. First, in terms of jurisdiction, the Court of Justice of the European Union clarified that it needed to address which dispute could be taken to arbitration under Article 26, paragraph 2c of the ECT. Even though the case in question wasn't within the EU, the CJEU explained that this didn't stop its authority. Also, it noted that this automatically didn't mean that Article 26, paragraph 2c of the ECT applied to disputes within the EU. Now, in terms of the fundamentals, the CJEU ruling served as a reaffirmation of the fundamental constitutional EU principles while addressing three crucial aspects of the arbitration clause compatibility with EU law, exactly as it did in the ACMEA decision. First, the court underscored the potential involvement of EU law in disputes handled by arbitration tribunals, given their authority to interpret and apply relevant legal framework. Secondly, the Court of Justice of the European Union examined whether these tribunals were integrated within the Union's judicial system, ultimately concluding that they were distinct entities with their own jurisdiction. Lastly, the court emphasized the importance of subjecting tribunal awards to review by EU member states to maintain the Union's judicial authority over EU law interpretation and application. So these three criteria define the incompatibility of the arbitration clause within the ECT with EU law, due to the fact that, firstly, arbitration tribunals constituted within Article 26, paragraph 6 of the ECT are required to interpret and even apply EU law. Secondly, such tribunals are not located within the judicial system of the EU and cannot be regarded as a court or tribunal of a member state within the meaning of Article 267 of the TFEU. Thirdly, awards rendered pursuant to Article 26 ECT are not subject to review by a court of a member state capable of ensuring full compliance with EU law and guaranteeing the question of EU law. and if necessary, be submitted to the Court of Justice for preliminary ruling.
And Charles, could you elaborate on the far-reaching implications for intra-EU arbitration? Why is this judgment significant in the landscape of arbitration, particularly concerning the relationship between EU law and investment arbitration?
Well, absolutely. Thank you for your question. This judgment holds significance for several reasons. As we have discussed, the implications of this decision run much wider and much deeper than the mere notion of investment under the ECT. Without a doubt, Comstroy will be used by EU member states defending against a tribunal's jurisdiction in intra-EU ECT proceedings. However, concerning arbitration under ICSID, referring to the International Centre for Settlement of Investment Disputes, Comstroy is generally deemed irrelevant for several reasons. Firstly, the ICSID tribunals have sole authority to decide on their jurisdiction, as stated in Article 41, paragraph 1 of the ISSID Convention. Consequently, the ISSID tribunal may reach a different conclusion than that of the Court of Justice of the European Union. Secondly, the ISSID proceedings and awards operate within international law and are distinct dispute resolution system, separate from the EU legal framework. Thus, they are theoretically unaffected by EU law and its evolution. This might not be the case for ad hoc arbitration conducted under UNCITRAL rules or Stockholm Chamber of Commerce, where the arbitral seat is within the EU. These arbitrations are subject to the domestic jurisdiction of their seat and its lex arbitri.
Thank you for that clarification. Now, looking ahead, how do you anticipate this judgment will impact future investment arbitration proceedings within the EU and under the ECT?
This judgment is likely to have significant implications for future investment arbitration within the EU and certainly under the ECT. It will lead to a shift towards resolving investment disputes through domestic courts or alternative mechanisms within EU legal framework. However, Comstroy does not, nor can it not, modify directly the express terms of the ECT itself. So for now, the ECT remains in force between all contracting parties, which includes all member states, as well as the EU. Indeed, a modification of the ECT to remove its application between the EU member states would require the participation of all 53 contracting parties. Now, I'll say this to conclude. The Comstroy ruling aligns with the broader EU effort to reform investment law, including the ECT. This decision is expected to stimulate discussion about establishing a multilateral investment court as advocated by the EU Commission. Within the context of modernizing the ECT, the judgment aligns well with the EU Commission's reform proposal. So while the Adrien ruling resulted in the termination of intra-EU bilateral investment treaties, the fate of the ECT within the EU remains uncertain.
Thank you very much for your insight, Charles. And thank you all for following this week on Future of Europe, discussing the EU legal development. This is all for this week, folks. We will see you next week. Don't forget to like and subscribe, and see you for another episode of The Future of Europe.